Hello everyone, myself Professor Dr. Rajashree Jawale, Assistant Professor, Ismail Sahibullah Law College, Satara. Here I am going to discuss with you about the salient features of Constitution of India. So, this article I have taken from legalbytes.in. This is by Mainab Shekhar. So, as we stated previously, Constitution of India is the supreme law of the land. When we talk about its broader nature of Indian Constitution, it is the lengthiest constitution in the world. It is a very comprehensive document and includes many matters which could legitimately by the subject matters of ordinary legislation or administrative action. When we talk about Government of India Act 1935, this is the base of our Indian Constitution, which was after all basically a statute, was used as a model and an initial working draft, and large portion of it got reproduced in the Constitution. Types of Constitution. Our Constitution is a written Constitution. Constitutions may be written like the USA Constitution or unwritten and based on convention like the British Constitution. Indian Constitution is a written Constitution. Through conventions also play a part in this. They are keeping with the provisions of Constitution. It originally contained 395 articles and 8 schedules. Now, presently, 395 articles, but now it's a total 448 articles divided into 22 parts and 12 schedules. Rigid and flexible. Constitution may call rigid or flexible on the ground of the amending procedure being difficult to easy. Federal constitutions are usually classified as rigid because of their difficult amending process. Indian Constitution may be said to be a combination of rigid and flexible. It cannot be easily amended. Third is parliamentary or presidential system of government. India is a republic, that is, the supreme power rests in all the citizens entitled to vote. The elector vote and is exercised by representatives elected directly or indirectly by them and responsible to them. And the head is the president. President in whom all the executive power vests and in whose name it is to be exercised. He is also the supreme commander of the armed force. However, unlike the USA president, Indian president is only a nominal or constitutional head of the executive. He acts only with the aid and advice of the real political executive, which is the Council of Ministers. The ministers are collectively responsible to the popular House of Parliament. So, you can read this. As according to Dr. B.R. Ambedkar, he stated, in the Constituent Assembly, the draft constitution in recommending the parliamentary system of executive has preferred more responsibility to more stability. However, some commentators argue that it causes political instability and dysfunctions, etc. Fourth is parliamentary sovereignty or judicial supremacy in India. The Constitution has arrived at a compromise between the British sovereignty of Parliament and American judicial supremacy. We are governed by the rule of law, and judicial review of administrative action is an essential part of rule of law. Thus, courts can determine not only the constitutionality of the law, but also the procedural part of administrative action. The Supreme Court may declare a pass law or law passed by the Parliament ultra vires as being violative of the Constitution. Parliament may, within certain restrictions, amend most part of the Constitution, but they cannot change the basic structure of the Indian Constitution. Next is universal adult franchise. Dr. B.R. Ambedkar stated that the Constituent Assembly, that by parliamentary democracy, we mean one man, one vote. Almost as an act of faith, the founding father decided to opt for universal adult suffrage, with every adult Indian without any distinction at once having equal voting rights. This was particularly remarkable in the context of the vast poverty and illiteracy of the Indian populace. When secular state, India has been declared secular state because of its policy of non-discrimination towards any religion. All religions are held equally in high esteem by the state, and there is no state religion, unlike a theocratic state or a preference for a particular religion. Then, Charter of Fundamental Rights. Fundamental rights incorporated in Part 3 of the Constitution are the inviolable rights of the individual or citizen against the state. Any law or executive action depriving an individual citizens of his freedom, for example, can be challenged in Supreme Court or High Court. The Constitution also lays down the machinery and mechanism for the enforcement of these rights. In the United States of America, their constitution, the fundamental rights were expressed in absolute terms, but there can be no absolute individual rights. For the rights of each individual are limited at least by similar rights of other individuals. Directive principles. The directive principles of state policy, which are included in the Indian Constitution in Article 36 to 51, inspired by the least precedent, are a unique features of our Constitution. Most of the socio-economic rights of the people have been included under this head, even though said to be not enforceable in court of law. These principles are expected to guide the governance of the country. They are in the nature of ideals set by the founding fathers before the state, and all the organs of the state must strive to achieve them. In recent years, the directive principles have increasingly assumed greater relevance and importance not only for the legislature but also in the eyes of court. Next is fundamental duty. By way of 42nd Constitutional Amendment Act 1976, Constitution added a new part to the Constitution under the head Fundamental Duty. It lays down a code of duties for all the citizens of India, and these fundamental rights are really very basic fundamental duties. Citizenship. We are having only one single citizenship, and that is Indian citizenship. Independence of judiciary. Our judiciary is independent. The Constitution of India establishes an independent judiciary with powers of judicial review. The High Court and the Supreme Court form a single integrated judicial structure with jurisdiction over all laws, union, state, civil, criminal, or constitutional. Unlike the United States, we do not have separate federal and state court system. The entire judiciary is one hierarchy of courts. It not only adjudicates disputes and acts as the custodian of individual rights and freedoms, but also may from time to time need to interpret the Constitution and review legislation to determine its vice versa the Constitution. Next is the Union and its territory. The Constitution of India does not protect territorial integrity of state. Part 1 of the Constitution, comprising Articles 1 to 4, provides a content mechanism for effecting changes in the Constitution of state or union territories of the Union of India. There are at present 29 states and 7 union territories in the Union of India. Then special status of Jammu and Kashmir. By virtue of Article 370 of the Constitution, the state of Jammu and Kashmir enjoys a special status within the Indian Union. It is the only state possessing a separate constitution, which came into force on 26 January 1957. But now if we talk about amendment in 2019, the special status of Jammu and Kashmir has been removed, and now Jammu and Kashmir, the state is similar like other states in India, and their constitution is also not operative today. They are binding for the Indian constitution only. Then Panchayat Raj and Nagar Palika institution. The Constitution 73rd Amendment Act 1992 and 74th Amendment Act 1992 have added new Part 9 and 9A to the Constitution. Under these two parts, 34 new articles and 2 new schedules 11 and 12 have been added. These amendments do not apply to the states of Meghalaya and Mizoram, Nagaland and Jammu and Kashmir, Union Territories of Delhi, Hill Area in Manipur and Darjeeling in West Bengal also. These do not apply unless extended to scheduled areas and scheduled tribe areas under Article 244. So this is very important article on the features of Indian Constitution. As a law student, we need to understand the Constitution of India in depth. We need to understand the general principles which are established in the Constitution of India. So thank you.